All right, let's go ahead and get started.
Good morning, class. After doing this seminar live for over 40 years, here we are doing a video conference. Thank goodness for a digital age. If we were in person, I'd be giving you all a hug. And from here, I'm going to give you a virtual hug. So many of you are used to the Zoom format. For some of you, it's brand new. I congratulate people who are doing their best to try. At the bottom of your screen, you're going to see what we call a chat box. And in that box, people are always already writing here, but if you scroll to the top of the box, you'll see there's our handout that you can download. And there are our slides that you can download. And we're going to record this. And after the presentation, we are going to email it to everybody who's registered. So if you need a little more time to figure it out, or you have to call up your grandchild to figure out what to do, you can do it then. So we are in a new world today. Our seminar is going to go for about 90 minutes. During the 90 minutes, you can write your questions, your comments into the chat box down at the bottom, or the Q&A, the question and answer box down at the bottom. And 90 minutes is a long time for a Zoom, so we're gonna stress out your brains here. But after the 90-minute presentation, we are going to be addressing your questions. And your questions are important to us too, because we realize that we might need to explain things a little better or what you're interested in. So let's get the show on the road. That's our little disclaimer. What's the disclaimer about? How can you talk to lawyers without a disclaimer? What we're telling you today is general information. Whether it applies to your specific case, we have to review the facts of your case. So this is educational. And if you're concerned about yourself, just give us a call or email us so that we can talk to you individually.
Yeah, so again, thanks everyone for coming today. And so this is our annual What's New in Estate Planning seminar that we would typically give at the Remington Club, that this year obviously we're doing electronically. And so we are, in case you don't know, we are estate planners. Our offices are located in Rancho Bernardo. And so we focus on estate planning, setting up wills and trusts. We also handle administrations after a death. So that would be representing the trustee or an executor in probate. And this year it's been quite a year, with a lot of changes. So we're gonna go through all of those today. And if you have a specific question, which we're expecting about Proposition 19, we want to let you know off the bat that we actually did a webinar for that already. And so if you wanted to learn a little bit more about it, you can email us, and we have our email addresses at the end of the handout, and we can send you a link to watch that webinar, or you can just give us a call. But we will cover a bit surface level today. And so what are we going to talk about? Kind of two parts in our mind of how things work. We have recent developments in tax law. So that would be the estate taxes and gift taxes, generation skipping taxes. And of course, we also think about on the retirement side of things as far as income taxes. And again, like I mentioned a second ago, property taxes is going to be a big focus on the presentation this year due to Proposition 19. And we're just going to plow on through to what we call case law. So that would be cases that came out in the last year that could affect you personally, or we as estate planners look at all these cases that come out every year and try to figure out what went wrong. Why did it go to litigation? Why did it go all the way to appeals? And what could we do to avoid that situation? And so we're always thinking about these cases in the back of our mind when we're talking to our clients. And of course, you never know what could affect you personally. And so we try to have these cases be anecdotal just for fun as well.
We're going to start out with the federal estate tax. And you see our picture there, exempt. Well, maybe, what does that mean? The amount that can pass at death to your heirs and beneficiaries tax-free is the exempt amount, the federal estate tax exemption. How high is it this year? It's really high. It's 11.7 million in assets can pass tax-free to your heirs. What if your estate is over that amount? Congratulations, you have a big estate. If it's over that amount, the amount over the 11.7 million is taxed at 40%, and that tax is due 9 months after the date of death. What do we know? The exemption is going down. In 2026, the law already says the exemption goes back to $5 million adjusted for inflation. So the exemption in 2026 will be about $6 million. I can leave $6 million free of estate taxes. If it's over 6 million, there's the 40% tax. We also have a new Biden administration, and on their list of proposed things is to lower the exemption, perhaps to $3.5 million. So we know we have a very big exemption now. In 5 years, it's going down to 6, but before that, it possibly could be lowered.
Yeah, and this comes up, every year when we do our presentations about, people may be thinking, oh, this is for very, very rich people. Anyone that has more than $10 million, they're the only ones that need to pay attention to this. But we try to stress that tax laws could change, and according, to the history books, they didn't used to change so rapidly, up and down every year. But now we're looking at, very a state of flux for the changing estate tax exemption amount. And so as estate planners, we think, well, what can we do to minimize a potential estate tax for a client? And so again, we have this option called portability. And this has been around for now about 10 years. And this says that when one spouse dies, even if they don't have an estate tax issue, because they don't have, between a married couple, 10 or $11 million, even close to it, the surviving spouse could use their deceased spouse's unused exemption amount. So let's just say that a married couple has maybe $3 million of assets in total. Between the two of them, if they died at the same time, they could exempt that $23 million. So they're not even close to having a taxable estate. But what if it's the situation where one spouse dies when the exemption is really high? So let's just say it's $11 million when the first spouse dies, and the surviving spouse is going to live on for many, many years. And we don't know what the tax laws are going to be when the surviving spouse passes away. What if they do only have maybe a $3 million estate? And we say only $3 million, but what if that's something that could grow in the spouse's lifetime, that over time it just doubles. It's up to $6 million at the time of their death. If they have a $6 million estate at the surviving spouse upon their death, and the exemption at that time is only $5 million, well, now they have $1 million of a taxable estate that under today's laws would be taxed at a rate of 40%, which is a very heavy tax. What could we have done when the first spouse died to minimize the potential tax when the second spouse dies? And we do that, what we do is what's called a federal estate tax return. So we're actually filing an estate tax return with the IRS, really just to report what are all of the assets. So again, there's no tax due by filing the return. You're just reporting what are the assets and their values. And on the estate tax return, we elect portability to use the deceased spouse's unused exemption amount. We call it the DSUI. So again, in that example that I went over, if the first spouse dies now, they have a whole $11 million that they haven't used because everything's going to their spouse. That surviving spouse could file the estate tax return now, after the first spouse dies, elect portability, and now they have their own exemption. In that example, let's say it's $5 million, plus their spouse's exemption of $11 million. So now, if they die and the estate is the size of a $6 million, they do not have a taxable estate. So we were able to just file a simple informational tax return to minimize an estate tax when the second spouse dies. And so some people, what we really try to highlight is no one's going to tell you that you have to file this return. We'll think about it, and you know, we will tell you, but it's not something that your advisor, your financial advisor, or sometimes even the accountant says that you have to file, because you don't have to file it. And you may not know that you have this option to elect into portability. And so it's something that we're always keeping in the back of our mind, is what is the likelihood that the surviving spouse could have a taxable estate at the time of their death? And does it make sense to file this estate tax return? And what if you're in the position where you've already had a spouse pass away and you're worried that you may have a taxable estate in the future? How long do you have to file the return? Really, it's due 9 months after the date of the death of the first spouse. Plus, you can put it on extension pretty easily, up to maybe about 6 months later. But again, what if you've already been past that point? There is a rule that says you can go back up to 2 years. So again, if you feel like you've missed out on it, you may still have the opportunity to file the estate tax return to elect into portability. And along with that, because we know we have a lot of advisors and accountants on the line, on the Zoom today, and so we also let them know that there's other elections that you can make on this estate tax return that could be beneficial. And that's what we call the Q-tip election. So we won't go into maybe the details of why and the purpose of it all, but something to know that if maybe a married couple had that old AB trust that we used to do very routinely many, many years ago, if they still had that AB trust, you may have the option of doing this Q-tip election to get a double step up in basis on the Trust B assets. Again, if you don't know what that is, don't worry about that. It's really for the financial advisors and accountants to think about in deciding whether or not it makes sense to even file an estate tax return.
Okay, there you go. There's the fat separator with gravy. How could this possibly relate to tax planning? Well, lots of people say, wait a minute, I've got an $11 million exemption today. It's going to go back down to about $5 million in 2026. I'm just going to lose $6 million of exemption. It's just going to disappear on me. Can I use it now? What if I make a gift now and try to spend that top part of my exemption, which is the fat in the fat separator? That's the disappearing $6 million exemption. So people say, let's just make some gifts now. We'll spend down the exemption and I still have my $5 million gravy exemption left at my death. Well, so you would think. The government says when you make a gift, you must spend your exemption from the bottom. You have to pour out the gravy first before you even get into the disappearing exemption. So if you think you really do want to spend down that $11 million exemption before it disappears, you need to be making gifts that are over $5, $6, $7 million. You've really got to make some enormous gifts to spend down part of that disappearing exemption. So this is a strategy that would be used for people with really large estates.
Okay, so again, we've talked about estate taxes. So that's the potential tax at the time of your death. People call it the death tax. There could also be a gift tax. So that would be a tax on a gift that you make in your lifetime. Really, it's just a transfer of assets. And so how much can you give without even having to pay a tax on a gift? It's that same exemption amount that they're tied to each other right now. So this year it's $11.7 million. So again, even if you made those huge gifts, some multi-million-dollar value gifts, you're not really paying a tax on the gift. Instead, you're just filing a gift tax return to report the gift. And so this is, again, just an informational return, not to pay a tax on it, but you're just filing to say, I made this, gift of this property or this, securities, this investment account to my child, and this is the value. And that's all you have to do on the return. And of course, people want to know every year, how much can you gift without even having to worry about filing a gift tax return? And this year it's $15,000. And the way it works, it's going to be $15,000 per person per year. And so between me and if I give each of my 3 children $15,000, I could do that without having to file a gift tax return. And my wife and I could combine our amounts. We're two separate people, two separate annual exclusions, where we could each give, or we could give $30,000 to each of our children without having to file a gift tax return. And again, that could be every year. And of course, what if you want to give more than that? You're a very generous person. You could pay for anyone's medical or educational expenses in an unlimited amount. And they don't, again, it doesn't have to be related to you. It could be friends, neighbors, family, whoever. If you wanted to pay for their medical insurance or their tuition or these qualified educational expenses, you can put any amount of money towards that without having to worry about a gift tax return if you pay it directly to the provider of the services. So you can't reimburse somebody for the tuition that they paid. You would have had to pay the school directly. And you can't help repay a student loan, even if you pay that institution directly, the lender directly, the loan was already incurred by the person. So all these have to be done to the provider directly. And again, a big issue or a big discussion point when somebody talks about making a gift is we do talk about carryover basis. And so we'll talk about a lot of that today, but just as a brief reminder, as an example, let's say you bought some stock for $100 a share and it appreciates to $200 a share. There's all of this gain that's in there within that appreciation. If you sell the stock, you pay the tax on the gain. If you don't sell it, there's no tax because you haven't realized the gain. And if you make a gift of that property to a child, in an example, they take the same basis. So there's that carryover basis that carries over to the recipient. So if they are to pay the debt, if they are to sell that stock, they do pay the tax on that. And the reason is, as opposed to what would happen otherwise than carryover, if you die owning those stocks, that basis gets stepped up equal to fair market value on the date of death. So there's always going to be this trade-off in taxes that we're always going to be thinking about. Okay, we finally got to it already. So we're talking about property taxes. So again, we went over estate taxes, gift taxes, and now we're shifting our mindset to property taxes and specific to California real estate. So we are California attorneys, and so we just focus on California property taxes. And if you remember, there was an election not too long ago, it seems like a long time ago, and we voted for a new president, and then we had a state election where we voted on various propositions. One of them that passed is Proposition 19. And this affects a couple different things. It's property taxes if you're 55 and older, or disabled, or a victim of a wildfire, that you can buy, sell your home, move to another property, and preserve your property taxes, which is great. But on the estate planning side, we would focus on inheriting property. And California Proposition 19 severely affects what happens when a property passes from a parent to a child, that the property taxes could be changed quite a bit. And so we're going to go through what that change would be today.
In order to understand the change, which occurs on February 16th, 2021, and our phones have been ringing off the hook, there is a deadline, we have to understand what was the law from the past. So we're going to go in the Wayback Machine, and we're going to remember Howard Jarvis in the late 70s had a voter initiative, created a ballot measure called Proposition 13 to help keep property taxes down, that they could only accelerate by a certain amount every year. So here we have the iconic, beautiful home. I think we're on the beach in La Jolla somewhere. I can only imagine what this home is worth. And the parents bought it back in the late 70s, let's say. And their property tax bill is an astonishing, maybe $2,000 a year, even though the home might be worth $20 million at this point. Well, until February 16th, the rule is that parents can transfer to their children their primary residence of unlimited value, and the children take the parents' property tax base, which means they keep paying the $2,000 property tax bill. It's astounding. They can use that home for anything they want. They can rent it, they can live there, they can make it an Airbnb and get their neighbors frustrated. Unlimited what they can use it for, unlimited what the value of the property can be. So that is the rule that we've been living with for 40 years. And it's going to change on February 16th. But let's see what the second rule is that we've been living with. There's another rule that pertains to parents transferring other property to their children. And here we're talking about rental property, commercial property. I'm from Los Angeles. I was looking for an iconic symbol of commercial property, and there I found the Capitol Records building, which you see from the freeway all the time. So if the parents own commercial property, even just a small residence that they're renting, until February 16th, they can transfer that to their children, and the children keep the property tax base, their parents' property tax bill, on the first $1 million of taxable value that the parents transfer to them. Well, what's the taxable value? We're talking about the property tax assessed value. So you look on your property tax bill in the right-hand side of the bill, and you'll see what the taxable value of your property is. Until February 16th, you can transfer rental properties or raw land up to $1 million of value, and there's no reassessment. There's no change of ownership. Each parent has the right to transfer the $1 million. So what's going to happen on February 16th? Daniel, tell us about the change.
Yeah, so after February 16th, all transfers of real estate, so again, a parent dies after that date, and now the children are going to inherit the property, or even gifts of property after that date would fall under the new law, which says the only way the child can inherit and keep the parent's property tax bill is on the parent's primary residence, so where they were living at the time of their death. And if the child moves into that property after the parent dies, that's the only time that the child can keep the parent's property tax bill. So in all other situations, the property taxes will be reassessed to full fair market value. So the first thing we're thinking about is, well, what about all the other properties? So if there's rental properties or investment properties, what happens to those? Again, since the parent wasn't living there at the time of their death, no matter what, even if the child moves into one of those houses, the property taxes will be reassessed to full fair market value. So back on the home, if it's the parent's primary home and the child moves in, makes it their primary home after the parent passes away within about a year, that's the only time that the property taxes would stay the same. Not only that, it's not an unlimited amount that passes as far as the value of the property to the child for property tax purposes. So here we say on the slides, the exclusion is limited to the first $1 million over the assessed value. So let's take a situation where maybe mom bought a house, in Rancho Bernardo, and bought it many years ago for $100,000. Maybe he's only paying, $1,000 a year in property taxes by now. And it's gone up just a little bit every year, but she's been able to hold on to a very low property tax bill. And going forward, if the value of the property at the time of her death is now worth, I don't know, maybe $600,000, again, it's less than $1 million over the assessed value. So if the assessed value is 100, it's worth 600,000, then it fully transfers without reassessment of property taxes if a child moves into that property after the parent's death. What if the situation, again, it's not in Rancho Bernardo and it's maybe more closer to the coast or that La Jolla property that's now worth $2 million. Again, the assessed value is 100, but now fair market value is 2 million. Only that first $1 million is excluded from reassessment. So the assessed value of the extra $900,000 above that gets added on to the property tax value for assessment, and now the child isn't paying, $1 million based off of the assessed value. So their property tax bill, if mom was paying $1,000, now goes up to $10,000 every year going forward. And so it's a huge shift in property tax law on how people children inherit property. And hopefully this isn't the first time you're hearing about it. because the deadline to do anything about it, again, is coming up pretty quickly here. And so here's just to also show, actually, again, what do the slides represent? We're trying to ingrain in your mind what's happening. So here is the children maybe reluctantly moving in to their parents' home, or a husband and wife, that they move into the mom's home who just passed away in order to keep the property for the property tax value. Again, if maybe they wanted to turn it into a rental property after the fact, the numbers may not work out anymore if the property taxes are doubling, tripling, quadrupling, that they may not be able to keep the property. Again, so here we have the rental property, so that other property exclusion, investment property, commercial, industrial, that was passing from a parent to a child, no matter what, will be reassessed. So here's the child getting their checkbook out to pay those big property taxes every year.
So what are we doing in terms of planning for Proposition 19? It inevitably involves a lifetime transfer of real estate before February 16th. That's why it's a big rush. And when families come for advice, the first thing I say is, hold your horses. Are you sure your kids want to keep the property? You see the benefit of transferring the property, but you need to have a heart-to-heart talk with the kids. If they're not going to keep the property, we don't need to worry about maintaining a low property tax. They're going to sell it. So here's an example, a beautiful home that the parents had. They raised their children there. There were weddings there. There's huge emotional equity in this house. But when the parents talk to their children, the children say, we don't want to live that lifestyle that you have. We don't need a grand house. We're from a different generation. We don't want to maintain, oh my gosh, every year you're paying for landscaping and this and that and the new roof. We have a different lifestyle. Maybe we want to live downtown. So you really have to have a talk with your kids.
Yeah. And again, I'll mention that we did another presentation on this, so that'll go into much more detail. But what are some of the planning opportunities? And we put death at number 1. And it's not to be funny, but it really is one of the more commonly questions we get asked, is what if the parents, mom or dad, already died, and then the property's still in trust, or we just haven't gotten around to distributing it out to the children yet? That's okay. We have our Board of Equalization. So that's the governing body for property tax laws. And they said that the date of change of ownership on an inheritance comes at the time of the death. And so for all those people, we're saying, okay, you're safe. Similarly, what if you already inherited a property from a parent? What happens to your property tax bills after that date? And it'll stay the same. So if you've already had the situation where we, work with you to get the parent-child exclusion on the property that you own, again, you don't live there, you do live there, it doesn't matter. Whatever's happened stays the same. So your property taxes are not going to go up. Another question that we get asked is, what about between spouses? So again, in the event of the death of a spouse, property taxes they don't go up just because your spouse passed away. So that part stays the same. What we are thinking about is, well, what can be done? And other than dying before the next couple of weeks, and a very simple option is just to make an outright gift of the property. And so all you would have to do is prepare a deed and sign it saying, I'm now transferring this property to my child. And if that's done before February 16th, then you're under the old law. So if that's not your primary home, it's another property, and it's less than $1 million of the assessed value on the property tax bill, that property transfers and the child keeps the property tax bill. Of course, you also have to file a gift tax return. So you would need an appraisal on the property, file the gift tax return, but that part's not due until April of next year. So you would have time to do that. So as long as the deed part is accomplished before February 16th, then you're safe for keeping your old property tax bills. And of course, people want to just say, oh, let's just add my child on title, or I'll just give it to them right now. And again, we say, well, let's really think about this, because there's going to be a lot of trade-offs. Again, here's that picture that we have on the slides of this person being pulled in all these different directions, because there all are these different trade-offs of transferring the property. The biggest one, like I mentioned earlier, is going to be the trade-off of the step up in basis. So again, let's say that dad bought his home in the 60s and paid, again, $100,000 for it, maybe moved out, bought another property, now lives here in San Diego and has a nice big house and this rental property that he's held on to for many, many years. And he's been renting it out, so he's been taking depreciation deductions and reducing the cost basis. So even if he bought it for 100,000, he's depreciating it, and now the cost basis is going even lower. And if the property is worth, let's say $1 million today, there's all this gain. If he were to gift that property to a child, the child keeps the same property taxes, but they also take the carryover basis. So if the child ever decides to sell the property, they are now paying a huge capital gains tax. Whereas if the dad continued owning the property until the time of his death, new basis, when it goes to the child, again, if they keep it, they do pay more in property taxes because it's the full fair market value on the assessment. But if they were to sell it, they're not paying much gain if it's sold, especially if it's sold right after death. There's no gain. Whereas, again, if it was a gift, they get carryover basis. So this has been coming up quite a bit. And so in one example, again, just that I went over, it didn't make sense to transfer that property to the child in the lifetime. And we crunched the numbers, and what was the holding period? So how long did the child have to hold it to make it worthwhile to pay low property taxes and sacrifice the step up in basis? That holding period was something like 30 years. So again, it was really risky to do that type of transaction because if the child were to sell the property in any less than 30 years, the numbers wouldn't have made sense to do it. You wish you wouldn't do it, wouldn't have done it. But another situation very similar where a man bought a property in Los Angeles, his first home, owned it with his wife, and then they moved down to San Diego and continued owning that Los Angeles property. When the wife died, they owned the property. And under community property laws, it did get a new income tax basis. And then the son moved into that property later on and is now married and raising his family in that house. And so it really made sense to make the gift because with the new basis, there was not a lot of capital gain after mom had passed away, that it was okay to transfer that over to the child because the dad still had that low property tax bill. And so that was a very good decision to make the transfer in his lifetime. Again, we also don't want to sacrifice practicality in your estate plan, but this was the only child. He was going to inherit everything anyways. He already lives in the house. So it made a lot of sense to make that gift. But what if the child had creditor problems or the dad was concerned about the child's marriage and that he could go through divorce? Again, these outright transfers means that child now owns the property. So it's their assets. If they go through a divorce, they get sued, it's subject to those, creditors. Similarly, what if the parent has rental property? The child doesn't live there. It's rented out and the parent receives rental income from that. Again, if they gift the property to the child, they can no longer receive the rental income. They don't own the property. If they try to have maybe a backdoor deal to continue getting the rent, that could be seen as not a valid transfer, and maybe it won't qualify for that parent-child exclusion. So now you've sort of shot yourself in the foot because you get increased property taxes now, and you don't get the new basis because the parent doesn't own it at the time of their death. So what are some other strategies that people are thinking about? And another one is just a general irrevocable trust. So that would be, instead of giving it outright to the child, the person would make a trust, put their property in the trust, and the parent can still be the trustee. So they're in charge of managing the house and deciding whether or not it's sold and can be in control over it. However, the child still needs to be the beneficiary of the trust. So any benefits, money that comes off of the trust, the child still needs to be able to receive those benefits. It can't go back to the parent. So again, it wouldn't really make sense if the parent does it for their own house, because they would have to pay rent to be able to live there like you would on a normal property. But maybe on an investment property, it would make sense if the parent's willing to give up the right to that income. And just because people are asking us about it, it seems like now everyone's Googling Prop 19 after it passed, that there's a lot of sophisticated transactions that exist out there, these irrevocable trusts with what we call like a 2038 power. Some attorneys are just really good at marketing, so they've already labeled them, property tax savings trust or Prop 13 trust, something like that, or sales to an IDGIT, which is an irrevocable or intentionally defective grantor trust. Part of the problem of why we're concerned about doing that for people is that it's not tried and true. So the way it works, I mentioned the Board of Equalization earlier. So they are the governing body of our property tax laws, and they delegate to local assessor's office. So every county has an assessor's office, but all the rules come from the Board of Equalization. And they, give us like annotations. So they tell us what works and what doesn't work and everything. And because Proposition 19 wasn't written by them, they had no involvement in the preparing and passing Proposition 19, that they didn't have time to really interpret the law before this February 16th date. And they put out all this information saying, we don't know how this is going to get interpreted. So they're going to take it on a case-by-case basis. Future legislation is going to have to pass. And so the concern about these new trusts to preserve property taxes, it's just a brand new strategy that hasn't been tested before. And so there's no guarantees that it would work. So it's a bit, we're a little more conservative in advising our clients. However, going forward after February 16th, we're going to have a brand new mindset. We no reason to look in the past, that possibly using entities like an LLC is going to be the way to go going forward to minimize property taxes when property is passing to children and grandchildren. And so that'll be something that will be implemented a lot more regularly going forward. It used to be, because properties within an LLC don't qualify for the parent-child exclusion, that it was kind of an easy analysis to say, hey, just don't have it, and then all this property can go to your children without reassessment of property taxes. But since that law is changing, it's likely that people are going to be relying on these LLCs a lot more.
All right, one more layer of taxation. Get up and wiggle a little bit so you can take it all in. IRAs, or retirement plans, whatever your retirement plan is. We already talked about estate taxes, and at the point of a death, your IRAs, your retirement plans, are part of your estate to calculate whether there is an estate tax due. On top of the estate tax, these IRAs are subject to income tax. And I'm going to review a law that changed in January of 2020, over a year ago, but people are just kind of coming to realize it after a death occurs, that the rules have changed. The law called the Secure Act was passed over a year ago, and this is how it works. We're all used to required minimum distributions that you take over your life expectancy. And for those of you who are over a certain age, you're already taking your required minimum distributions. And in the past, we always said, oh, the beneficiaries, they'll be able to take required minimum distributions, possibly over their life expectancy. I had a really, really smart client who, as soon as he realized that, made his grandchildren the beneficiaries of his IRA, because they had the longest life expectancy in the family. They would only have to take out a little bit, pay income tax on that, and the rest of the IRA could grow tax deferred, where we're always looking for a way to stretch out the withdrawal of the IRA. Boom, along comes the Secure Act. And the Secure Act says only certain special beneficiaries can use life expectancy. Only certain beneficiaries. And they're called eligible designated beneficiaries. Who needs to know this? All the accountants out of there need to know. The EDBs. Everybody else doesn't get life expectancy. Other people get a 10-year withdrawal. They're called designated beneficiaries. And we'll take a look at who those are. And the worst of all is, in certain cases, there's a 5-year withdrawal. After a death, the IRA must be totally withdrawn within 5 years, and all the income taxes have to be paid. So when we're doing estate planning, we look at those retirement plans as a special situation. We have to think about who's being designated as beneficiary. So let's look at the special beneficiaries. The people who still get life expectancy are a spouse, a minor child until they're an adult, A disabled or chronically ill person, that's a person who might have a special needs trust for their benefit. And a beneficiary less than 10 years younger than the owner. Who might that be? That could be your sibling who's within 10 years of your age. And you might say, in light of that, maybe I was going to leave a bequest to my sister or my brother. Maybe I'll make them beneficiary of all or part of my IRA so they can take it out over their life expectancy. Who gets the 10-year withdrawal? All your kids and all the other beneficiaries. So if I name my children as the beneficiaries of my IRA, I thought I was so smart they could draw it out over their life expectancy. No more. If I die, they have 10 years to withdraw the IRA and pay the income taxes. They could wait till the last day of the 10th year to do it. They don't take required minimum distributions. If they do wait till the last day, they have to absorb all that income all at once on their tax return, their income tax return. So part of the strategy that beneficiaries will have is, when do I start taking withdrawals? And this is where you're going to see, do I have other deductions? What else am I doing? What's the result on my income tax return? What about the 5-year? We call that blowing the IRA. You never want this to happen, that the IRS says you have to withdraw, beneficiaries, you have to withdraw that account within 5 years. How could that happen? If you put your estate as the designated beneficiary on your brokerage account, for instance, this is your IRA account, don't write down your estate, name real people. What if there's no beneficiary? That could happen accidentally, that there's no beneficiary. What if you named someone, but they don't outlive you? They're a deceased beneficiary. And last of all, a trust, which is not a see-through trust. So a trust can qualify for life expectancy or the 10-year withdrawal if it's called a see-through trust. The IRS says, we see who the beneficiaries are. We know it's the spouse. We know it's the children. It can be payable to a trust that's managed for them because we can see who the designated beneficiaries are. But if we can't see who the designated beneficiaries are, you're stuck with the 5-year withdrawal. And that would be a situation, believe it or not, where you have a charitable beneficiary. That disqualifies the trust as a see-through trust. So if you're making an IRA payable to a trust, get that trust reviewed to make sure it's a see-through trust. To make sure if it talks about required minimum distributions, it only pertains to the special beneficiaries. So we have to take a look at those old IRA trusts, and definitely keep a copy of your retirement plan beneficiary designation with your will and your trust.
And that actually is the big takeaway in all of this. So again, it's good that we're teaching you the different beneficiaries and how it works, but really check your plan beneficiaries. And so no matter what we do as estate planners, again, we could say your trust goes to all these people and it's all this sophisticated language. If the retirement plan company, Schwab, Fidelity, Vanguard, anyone, TD Ameritrade, if you set it up with them and named your brother as the beneficiary, 30 years ago, and you never changed it, it doesn't matter what your estate plan says. It doesn't matter what the will or the trust says. Those plans pass according to the designated beneficiary that they have on file. And so it's very important that you would check who it is. And if you want to change it, then you would, hopefully under the advice of your attorney, change it to be the right people directly with that company. So you would get the forms, a change of beneficiary form. Nowadays, you can download them and you would just write in who you'd like to be the new beneficiary and give it back to them. And that's what it'll be on their plan. And again, I'll reiterate, if you had your trust named, even if we told you to name your trust as maybe a beneficiary on a retirement plan, it is still important to have that reviewed, because since the Secure Act passed just last year, we've had to change the language in our own see-through trusts. And so it could be that you have bad language in the trusts that may not work, even though they would have at the time. And of course, we always think about should be the first beneficiary and maybe a second or contingent beneficiary. And that's very important. I'll give you an example. So just now, right now, I'm working on a matter where one of our clients, husband and wife, were married, named each other as the primary beneficiary, but didn't name anyone as a backup. And unfortunately, the wife passed away. And then the man came to see us. We helped him with his personal estate plan and said, okay, now change the beneficiary of your retirement plan to be, your other family members. And, he just never got around to it and died without having really anyone named on his retirement plan. And so that retirement plan will now have to go through probate. And again, hopefully if you're on here, you know how bad probate is and why we want to avoid it so much, that it's very unfortunate that all he had to do was just fill out a form with the company, the bank really, to change the beneficiary, and it just didn't get done. So always check your beneficiaries. And when we talk about retirement plans, we're saying IRAs, Roth, SEP, 401k, 403b, and then even annuities. So anything that you name a beneficiary to is a plan that has would have a beneficiary to it, a plan beneficiary, and that you would fill out directly with that institution. Okay, so now we're going to switch our mindset to case law. So really, we've just been talking about taxes. So thank you so much, everyone, for hanging with us. And now we're going to switch our mindset to case law. And so this is where, again, we read all these cases that come out, and we try to reverse engineer it. Because again, we're estate planners. We plan to avoid these problems. And to know what problems could arise, you have to see what went wrong in other cases. And so we take a look at this, and then we're thinking, okay, how could we avoid this situation if the facts present themselves in a very similar way? So why don't you tell us about the estate of Eimers?
All right, we're getting over to our case law here. We're going to be talking about powers of appointment. Oftentimes, we set up trusts for the benefit of children. So I might say my estate does not go outright to my children. My estate stays in trust for my children to support them for the rest of their life. And at their death, the child has the right to say where he wants his share to go. If he doesn't say, it will go down to his children. And if he doesn't have children, it will go to my other children, the siblings of that child. So I can give my child the power to appoint where his share of a trust goes. And usually in the trust, I say, this is a power of appointment. He must specifically refer to this power of appointment when he exercises it under my trust. It has to be in writing. He has to deliver it to the trustee. I'm going to create this whole procedure of how does he exercise the power of appointment. Well, in the Eimers case, this is what the parents did. They set up a continuing trust for their children. One child wasn't married, didn't have children, and he wrote a handwritten will that said his own estate and his parents' trust goes to his two friends. After he died, there was a contest. Guess who wasn't happy about his share going to his two friends? His siblings, because they were going to inherit it if he failed to exercise his power of appointment. So this went to court, and the court had to decide, even though it looks like he intended to, he didn't adhere to the specific requirements written in the trust to exercise the power of the appointment. And for this reason, the power of appointment was void, it failed, and his share didn't go to his friends, it went to his brothers and sisters. So the takeaway message here is this is a very sophisticated power, a sophisticated document. There are times when you need to consult with an advisor. There are times when you do need your estate planning attorney to help. And that's the story of powers of appointment.
Okay, and another similar topic is really the formalities on executing documents. So again, power of appointment, it says refer to the original document that it gave you this power. So again, when you meet with your attorney, we're very formal in how we reference that. Very similarly, when we make an amendment or we revoke a trust, we're also very formal. So we always ask, let's read the copy of the trust to say, how does it tell us the procedure on amending the trust? Because the trust will specify how to change it. And so in the Kundal case, I was very unfortunate. So Jack was this elderly gentleman who became friends with a neighbor and kind of another neighbor that was actually an estate planning attorney. And so his one friend was, helped him take care of the house and do his yard work and kind of took care of all these things for him, and they became friends over the years. And so Jack, with the help of another neighbor estate planning attorney, prepared a trust for the benefit of his friend. And of course, they had a falling out. Jack felt that the friend was taking advantage of him and bilking him out of money, which he was, and went to another attorney to say, I don't want these people to be involved in anything. I want to revoke that old trust. So I want to, do away with it. I want to rip it up. And instead, I'll create a new trust, leaving all my money to charity. And so that's what he did. The new estate planning attorney revoked the trust and left it all to the charity. And then, of course, Jack died. And now his friend is suing to try to get the money that he believes is owed to him. And what was he trying to say? What leg did he have to stand on? He said that the method that Jack revoked the trust wasn't the right method. So the trust said, who can amend the trust is the person that created it. And so they would prepare a document, writing it down, saying this is what I'm changing, or this is how I'm revoking it. But it has to be delivered to the trustee, the successor trustee, and the drafting attorney. So again, that old trust had all these obstacles built into it to say, again, the friend and the original attorney didn't want Jack to make any changes to his trust without them knowing about it. So they put in all these obstacles and formalities so that they would have to be notified. And Jack didn't do this. The attorney just said, I'm amending the trust, I'm revoking it, and I sign it and deliver it to myself as the creator. And typically that's good enough. Perhaps the new attorney didn't read the old trust to see all the formalities. Luckily, in this case, though, the court did say that you don't have to rely on what the trust says as the exclusive method of amendment, unless that's what the trust says. You could rely on the statutory rule of how to amend a trust, which again is very basic, that the person who created the trust makes the amendment and then delivers it to the trustee, who's usually themselves. So your revocable trust, you are your own trustee. And so again, luckily, Jack, the new trust held firm. But again, from this, we really ingrain in our mind that we have to read the old documents to tell us how to change the trust. Again, you don't want to rely on this case law to be in this position to say why you were right, because again, by then, people are already fighting and you never want to be in that position.
Guess what? We've got an IRA case. Well, you're going to leave this seminar knowing about this IRA beneficiary information. In the Duval case, we have two unmarried partners, Carol and Pat. Carol had an IRA and she said 50% of it goes to Pat down the left side of the road and 50% of it goes to her brother down the right side of the road. And this was the form that she filled out with the brokerage firm. It's a 50-50 distribution. Years later, Carol and Pat sign a joint trust saying that everything stays with the surviving partner. Carol dies. The brokerage firm releases the IRA, half to Pat and half to Larry, her brother, because that's the beneficiary designation. Pat contests and says, wait a minute, that IRA should be part of the trust that's coming to me. Well, what did the court say? They said the beneficiary designation controls. By contract, that IRA, not part of the trust, goes to the two beneficiaries. It's not part of the trust. So when we're doing estate planning, when you're doing estate planning, those retirement plans, insurance policies, annuities, they are the horse of a different color. Despite what we write, you still have to check your beneficiaries, and we will bug you at the time to please check your beneficiaries. Get us a copy of your beneficiary. Keep it in your estate planning notebook, because that beneficiary designation controls where that asset passes.
Okay, next we're talking about the Dowling case, and this has to do with what we call undue influence. So the facts in this case was a woman befriended an elderly gentleman, very similar tale, that said in the event of my death, initially the man said, I'll leave everything to my only son. And that's the way it was, and that's how it was always going to be. And then after years and years of this relationship with this woman, more of a friendly relationship, the man and his son grew further and further apart. And it came to be that this woman was telling lies about what the son was doing behind the dad's back, and kind of implanting ideas of saying the son is stealing money from you, and he went to jail, and this is what he says about your, all these people around you. And so the man got very, very upset at his son, changed his trust, and of course, left everything to this woman who he had this relationship with. And unfortunately, the man passed away, and the son contested the change to the trust, saying this person, in this case, that last name, I'm not going to try to pronounce it, unduly influenced my dad to make changes. She lied to him, and so for that reason, the change to the trust should not be valid. And what's interesting in this case is a neurologist came up with this scam model for determining undue influence. And so again, when we're meeting with people, it used to be in person that we could always control who's in the room. We're aware of whether somebody was influencing our client to make decisions. And so we're always thinking about this undue influence issue. And what's nice about this scam model is it was very, it kind of quantified and organized the idea of what is undue influence. And so the SCAM stands for susceptibility, confidential relationship, actions and tactics, and then monetary loss. So in this case, the son went through each and every step of this to say, yes, this was undue influence. His dad was susceptible. He was old. He developed dementia. He was very alone. He was being isolated from the rest of his family. And so he was susceptible to what this person was telling him. He was in a confidential relationship with this woman. Again, she helped him with daily tasks of living and was very friendly with him. What were her actions and tactics? Again, she lied to him. She planted ideas in this guy's head of things that were not true. And then eventually monetary loss, pretty clear, he changed his trust to omit his son and leave it all to this person. And so again, it's maybe more and more difficult these days if we are doing our appointments by Zoom and telephone that we're not seeing kind of who's in the room and controlling it, but we still are assessing the client's capacity and whether they're being influenced to kind of go against their own free will that they would have made otherwise.
What do we have here? We have a pitcher pouring water into containers. What are those containers? That's a trust. That's my analogy for a trust. When you have a trust, you try to get all your assets in the trust while you're alive in order to avoid probate, your real estate, your brokerage accounts, etc. But we always prepare what we call a pour over will that goes with your trust. And the will says, in the event of my death, if I forgot to put something in my trust, it's still in my own name, I pour it over into my trust so it gets into the right container with the right distribution plan. Well, in the Wilkin case, what happened? It was a second marriage, and the wife in the second marriage had two sons of a prior marriage and a rental property that she had owned for a long time. It was clearly her separate property. So she went to her estate planning attorney to draw up a trust that the rental property would go to her son's separate property. In addition, as all lawyers do, he created a pour over will. The will said, all of my estate goes into that trust, that separate property trust. After the woman died, the sons said, sure, we get that separate rental property. And they said to their stepdad, by the way, we also get mom's share of the community property. You thought it was going to you. No, it comes to us because mom's pour over will said all of her estate goes into the separate property trust. Well, this went to trial and the estate planning attorney had to testify and said, really, we were doing estate planning only for her separate property. What should have been drafted is a will that said, all of my separate property goes to that separate property trust. And in this case, all my community property goes to our joint community property trust. So when you have a variety of trusts, I don't think you'll have this many, but you might have 2, you might have 3. Make sure the pour over will is clear about where your remaining assets go.
All right. Next, we talk about the Sachs case, and this one's a great illustration of really the right thing to do. So believe it or not, the client, the decedent, did really all the right things in this case, and it was just, I'll say, a bad son that was trying to fight it. And of course, what are we talking about? So here's our person keeping a list of all the records of lifetime gifts made to children. So in the Sachs case, Dad was very wealthy and had 2 children, and he would help them out from time to time by making gifts to them throughout their lifetime. And really, these were not gifts because the dad intended to have their amounts that he given to them over their lifetime kept track of, and ultimately it would be deducted from their inheritance upon his death. And this is a really easy thing to do, really, with your estate planning attorney, if we know about it. I know there's plenty of times that people help out their children and make gifts, and many times if people say, okay, I'll just, it's my money, I get to do whatever I want, even though I want to be equal with the kids, I'll be equal upon my death. So it'll be a blank slate, whatever I own at the time of my death goes equally among my kids. Other times parents are thinking, well, I've really helped out this one child so much in their lifetime, it's unfair to the other children or my other child that why does this person get all this money in their lifetime, and then at death it's also equally divided. So ultimately that child could be seen as getting more money from the parents. And in that case, there is a way to keep track of those gifts or really advancements that you make in the child's lifetime, in the parent's lifetime, that would be a record upon the parent's death, so that when it's ultimately divided upon the death, it is equal, taking into consideration the lifetime gifts. So in the Sachs case, this is just what the dad did. He kept a record, we call it a contemporaneous record. So every time he made the gift, he kept a record of it. And he said, this is the permanent record that I intend to keep track of in my lifetime, and upon my death, it will be deducted from your inheritance. So between the son and the daughter, he would just make these gifts and write it down and keep track of it. So these weren't loans. He wasn't expecting to get paid back. And of course, there must have been a lot of money at stake to even go to trial and have it published and ultimately get into our handout. So ultimately, the son received $460,000 more in lifetime advancements than the sister. So again, there was probably a lot more than that, but the son ended up with about $500,000 more. And so he was upset at death after the dad died that that $500,000 was going to be taken out of his share of the inheritance. So he would, in his mind, get less than his sister. But again, through trial, it found out that no, everyone agreed that this was meant to be his permanent record. The son even said in email saying, yes, I understand that this money you're giving me is going against my permanent record. And the dad kept track of everything at the exact same time. So he kept this list of money that he would give out to the kids, kept it with his estate plan. And so the trustee was right when they took that into consideration. So again, as an estate planning attorney, if we know that these gifts are being made in your lifetime, we'll say, well, what do you want to have happen at death? Does it all just kind of disappear? You're not going to keep track of it. It's not worth it. Or is it going to be a loan? Are you actually loaning money to the child? And let's maybe formalize that. We don't want loans to just disappear after you're gone, that the child says, no, it wasn't a loan. Or is an advancement against the inheritance. So again, it could be a one-time thing. It could be every year you're making gifts. If you do want that considered as an advancement, it's best to keep a record of it, and we can always write a reference to these advancements in your trust. So to be very clear to everybody, to say, I'm keeping a record of these advancements, whatever is in that record upon my death shall be taken into consideration. Again, it's just as easy not to keep a record, and then it all just disappears, and that's where kids could sometimes end up fighting over these situations. So it's best to be clear in the estate plan.
All right, this is a really big case. Roth versus Jelly. I know we have attorneys in on the Zoom. This is a very big case for attorneys to know. What happened in this case? We had a second marriage, a husband and wife, and the husband said, my separate property will stay in trust for my wife for the rest of her life to take care of her. After she passes away, what's left will go to the children. And if a child dies, his share goes to his children. So that would be a grandchild of dad, and we call that person a contingent beneficiary. That person, that grandchild, would only inherit if dad died, the wife died, the parent died. Pretty remote, but it's possible that something could go to the grandchild. So what happened in this case? Dad did die, and the surviving spouse and the children decided, rather than having an ongoing trust for the stepmother where they're waiting for their inheritance, they would settle up, that a certain amount would be paid to the children right away. It was something over $2 million. And the rest of the trust would just be released to the surviving spouse. Keep it simple. They decided, let's go to court. Let's get a court order that blesses our settlement agreement. What did they do? They filed their petition. They said, here's our proposed settlement agreement. And they gave notice to the surviving spouse. They gave notice to all the children. We're all going to court. They did. The court said, fine, we agree with the settlement agreement. We give you a court order. Everybody go on along your way. So how could this ever become a problem? Well, one of dad's children died before his wife died. So that child's children, dad's grandchild, would have inherited that son's share, but for this settlement agreement. And that grandchild said, I never got notice of the hearing. I'm not bound by your settlement agreement, even though it was ordered by a state court. I have some other higher authority. I have the US Constitution. I have the due process clause that says the agreement that you made affected me, and I never had notice of the proceeding. So I want to throw out the settlement agreement. I want the inheritance I should have had from my dad. So this was quite a case, and the court held, yes, that the US Constitution due process clause is supreme over the state court order. So what does this tell us as attorneys? We used to think these remote contingent beneficiaries, we don't really want to have to give them notice. Now everybody's involved. People are going to be calling and they have their own opinions of what should happen. What a pain. But really, if it's possible that a contingent beneficiary could be affected, we need to be giving notice to those contingent beneficiaries. And that's certainly in the world of litigation. And even in the world of probate, we handle many, many probates. And we're used to giving notice to all the living beneficiaries, heirs at law. We now have to think down to the next generation, or who the contingent beneficiary is, that we should be giving notice to them too. It's a very big case.
All right, and just to let everybody know, so we'll go for about another 10 minutes or so, and then we'll leave time for questions, and we'll stay past the 90-minute mark if you want to just keep asking questions. So if you want to put your questions in the Q&A, we will answer them today. If you want to send us an email separately or call, again, you'll have our information at the last slide. Okay, next we're looking at arbitration agreements. So what the heck is that? So very commonly, in that fine print of many agreements, contracts, there's something called an arbitration clause. So that's the clause that says if everything goes topsy-turvy and you're going to sue us, that instead of suing us in court, you agree to go through arbitration. So a private third-party arbitrator will take care of it instead of the cost of going to court. And that's typically going to be favorable for the person that's kind of issuing the services. And so in the Holly case, there was this woman who needed to go to an assisted living facility, and she has already lost her capacity to sign contracts. So she lacks the capacity to contract. And so she, I believe, had dementia, and the kids were trying to take care of her and get her into this nursing facility. Unfortunately, mom never signed estate planning documents. And specifically, she did not have an advanced healthcare directive where you name somebody that can make medical decisions on your behalf if you can't make them for yourself. And so she didn't have the documents prepared, but the kids were still needing to take care of her. So commonly, you would go through what's called a conservatorship. So that's the court process of having somebody appointed over you. again, if you don't have your affairs in order, somebody has to go to court. So they get appointed over you as your conservator, and at that time are allowed to sign on your behalf on medical decisions, maybe even on financial decisions. So in this case, the the children signed mom into a nursing facility, signed the intake forms, signed her in, signed the arbitration agreement. They signed this before the courts appointed them as the conservator. So again, they were just doing, what their mom needed, not having to wait for the courts to appoint them as the conservator. And unfortunately, in this case, I think mom fell and passed away due to her injuries. And so the kids tried to sue the nursing facility, saying, wrongful death, you were negligent, all these other things. They were suing the nursing home. And the nursing home says, well, okay, let's go to arbitration. That's what the agreement says. And the kid said, no, I don't want to go to arbitration. I want to sue you in court. That's more favorable to us. We're more likely to prevail. And they said, well, you signed this arbitration agreement. However, because they were not the conservators at the time they signed it, the court held, no, they are not bound by this. So even though they are the ones that signed it on mom's behalf, they were not bound because they weren't properly authorized to sign it at the time. And so they were able to go to court to sue the nursing home without having to rely on the arbitration clause. So again, kind of not something that's going to affect very many people, but again, in our mind, it really shows us how important these estate planning documents are. And probably if you ever get sick and tired of filling out all these forms over and over again for all these companies, this is the reason why, is because they get sued. And they always want to have the right people signing it and all of these things.
There's my survivor picture. I had a lot of fun making these slides. All right, what happened in this case, the Placencia case? Dad has 3 daughters, and he relies on one of them primarily. Her name is Lisa. So they went and put Dad's brokerage account, his substantial investment account, in joint tenancy. Dad and Lisa as joint tenants with rights of survivorship. 24 years later, I counted the years, 24 years later, Dad creates a will and a trust. And the trust says, at my death, everything goes to my 3 children equally. Well, he had his brother-in-law help him writing the will. And in the will, they put a statement that I remove Lisa as beneficiary of my brokerage account. I want my 3 daughters to be equal beneficiaries. Did he go back to the broker and change the title of the account to be the trust? No, he left the title alone, held in joint tenancy. So at his death, the brokerage firm releases the account to Lisa, because in a joint tenancy account, there's an automatic right of survivorship. The account is released to the surviving joint tenant. Well, Lisa's sisters contested and said this brokerage account should have been part of the trust. And they're asking for a court order that it be distributed to the 3 daughters equally. So the court had to decide, do they even have the ability to make an order concerning a joint tenancy, a brokerage account? One law in California says if it's in joint tenancy, broker, you have the right to release it, and that protects the broker. But there's another law in California that says if beneficiaries can prove by clear and convincing evidence that the owner wanted this account to go to them, that they have a chance to prove that in court. They had standing to go to court and argue it. And they did argue it based on the statement in Dad's will that he wanted to remove Lisa and leave this account to all 3 of them. Well, the lesson here again is you don't want to be in court. As Daniel always says, you don't want to be in our annual handout. If you really want to change an account, instead of going to a joint tenant, that it should go according to the trust, get the change of ownership form from the brokerage account and make the trust the owner. Don't leave it in joint tenancy, which will result in potential litigation.
Okay, yeah, next we're talking about the Buzzkirk case. And so really, this was kind of fun to put in there because it has to do with somebody leaving the state of California. And again, if you thought, taxes were bad and you just learned about Prop 19 and you think you're on your way out to another state, this tells you to make sure you have your estate plan reviewed by an attorney in the state in which you reside. So if you're moving to Texas or Arizona or some other Florida non-income tax state, have an attorney there review it. So what happened in the Van Buskirk case is mom lived in California and had her estate plan prepared here and then listed her son as the trustee, so that the son took over in her lifetime. She lost capacity, but the daughter who lived in Idaho wanted mom to be closer to her so she could take care of her. A very common situation, move closer to the kids when they're able to take care of you. And so sister moved mom up to Idaho where she lived. And of course, things didn't work out the way they should. And then son sued the daughter for, taking mom or stealing money or something. And the son sued in California. And the daughter said, well, mom is in Idaho and I'm in Idaho. You have to sue up here. Again, there's all these ideas of personal jurisdiction. So where do you sue? California or Idaho? And the facts of this case held that because the mom created the trust in California, the trust itself says it's to be regulated under the rules of California, and the son, who's the trustee, is located in California. For all those factors, it makes sense to, yes, you would sue on behalf of the trust in California. And so again, if the mom maybe had her estate plan reviewed or updated in Idaho, if she was able to, then it would have occurred out there. So again, just keep in mind, you want to make sure that you always have your estate plan reviewed in the state in which you reside. Especially if you're a married couple, California is a community property state, but not all states are, most states aren't. And so they may have a very different way of doing their estate planning.
Here we have a picture of a breach of trust. A trustee has somehow violated a trust. So if you're the trustee of an irrevocable trust, you're managing assets for someone else, what's in it for you? What do you get? You can only get what the trust provides. So people come and say, can I be paid for my services? I say, wait a minute, let me look through the trust. I've got to find the paragraph that says the trustee can be paid reasonable compensation, or the trustee can be paid 1% a year. The trustee can be reimbursed for out-of-pocket expenses. And you have to sit there while we look for that paragraph, because you can only get what the trust provides for you. Can you pay your own medical expenses out of the trust? Probably not. Can you make gifts to your friends out of the trust? Probably not. Can you buy assets from the trust? Well, here we have the Cheng versus Cheng case. And it was held, not only could the trustee not buy assets from the trustee had to return the assets and was personally liable for double the value out of the trustee's own pocket for breaching the trust. Breaching the trust is a no-no. You want to be a squeaky clean trustee is what I tell my trustees. Can you sell the property to yourself? Can you sell it to a friend? Can you hire your family member as the broker to sell the property? All of this is a conflict of interest. And I had a very young trustee contact me recently, and he was wondering, what about this? What about that? And I said, if you're even getting that tickle of a conflict of interest, that you're even wondering, is there a problem with it? There probably is a problem with it. So you always want to check with your trust administration attorney. Are you allowed to do various things? And in fact, in a trust accounting under California law, you must disclose if you hired anyone who's related to you or you're involved with. You always want to keep this unbiased, that you're doing things above the table.
All right.
Oh, I keep forgetting this is my case. Okay. This is the O'Brien case. This is a fun case in a way. This is Hugh O'Brien, who played Wyatt Earp in the 1950s TV show. And he didn't get married till he was 81, but along the way, he had many children. And after he died, certain children popped up and said, I'm an heir. I have a right to take under Dad's will, even though Dad's will purported to omit anyone who might be his heir, and he left it to where he wanted to leave it. So this could happen. I had two women come in to handle their father's estate, and they were shocked that these two men showed up at the funeral and said they were Dad's sons. And Dad had been a Navy pilot, and whatever happened, happened. And they couldn't believe they had two brothers suddenly, and they were worried, were these brothers going to contest? They never did, which was rather interesting, but they did come to the funeral. So the court set up a way to determine who has the burden of proof to say the children are included or the children are not included. And burden of proof means who has to prove it to the judge, and that can really change the outcome. And the court said, if these children were born before Hugh signed his trust, they have the burden of proof to show that the only reason they weren't included is because Dad didn't know about them. That's a hard thing to prove, that had my dad known about me, he would have included me. I have to prove the only reason is that he just didn't know about me. So that would be a child who's born before Dad writes the trust. If the child is born after Dad writes the trust, the burden shifts. The estate, Dad's estate, has to prove there was an intention to omit those children who were already born by the time the trust was written. So as estate planners, we ask you, please be sincere and disclose who all your children are. And if anyone is being omitted, we need to write into that document that child's name and that it is your intention to omit them. You can't just be silent about it if you really want a good trust. We'll even ask you to write a handwritten letter that it is your intention to omit that person by name so that there is evidence in your own handwriting of your intention. So Daniel, now you can take it to our takeaways.
Yeah, so what are the big takeaways, for us this year? Again, the big one is Proposition 19. So that really is that huge of an effect on estate planning and property taxes on inheriting California real estate. So again, we have this deadline. It hasn't yet passed, but it's getting pretty close. That maybe there may be some people that may want to do these transfers before that deadline. And again, afterwards, how we talk to clients and setting up their estate plan, probably we're going to have to bring this up if you have real estate, that this will be the effect, in the future of, and when the child inherits, that they may have a significant property tax burden. And again, changes in the federal tax law, this is going to be a huge one. We know absolutely at the end of 2025, the federal estate tax exemption is going to change, but could it change sooner? Again, new president, new makeup of Congress, and it's on the wish list. And so if the exemption does go down, hopefully they give us enough time to sort of plan around it. But luckily, compared to Proposition 19, we do have methods in estate planning that Roberta has done many, many years longer than I have that do, work, and that we can confidently advise clients on how to do it. Yeah, so that's the end of the presentation. Again, I'm shocked that so many people stayed on for so long. We had over 200 people watching the presentation. And so again, you'll get a copy of the slides and the handout, and this is being recorded. So you'll get a link to watch that if you forgot something or want to forward it to somebody. You'll receive a link to watch that. And now, in the little bit of time that we have left, we'll just go through the Q&A to see if people have some questions that we can answer. And so the first one, it talks about, right, the exemption amount. So if you use up that full 11.7 million exemption now by making these really large gifts, what happens when the estate does go down or the exemption amount does go down in the future? And what happens? Do those gifts get brought back into the estate or not? And we do have a rule from the IRS that said, if you exceeded the gifting amount in your lifetime, that full 11.7 million, that is considered your exemption at the time of your death. So essentially, you used up the entire exemption. So whatever you have left is going to be taxable but the gifts that you made are not going to be brought back in.
I'll take that second question. You can keep writing your questions, by the way. We're going from the top down. A little bit about irrevocable trusts and capital gains. And I think we're talking again about Prop 19. And I'll give you a real life case. I have a client who lives here in Penasquitos in a very nice house. She came in to do her estate planning, and I said, "Who owns the house you live in?" And she said, "My mother in Florida owns the house, and I'll get it when she dies, and I'll continue to live here, and then it will go down and be held for my child." And I said, "Boy, I bet your mother in Florida doesn't know about Proposition 19. Why would they be reading in Florida about Proposition 19?" And I said, "If your mom transfers that before February 16th, then you can keep that very low property tax bill." And she said, "Would you please contact her attorney?" And she gave me the attorney's name, and we emailed each other. And I said, "You need to know about Proposition 19. And after consulting with his client, they decided they wanted me to create an irrevocable trust. Mom would be trustee of the trust, and mom would deed the property into that trust while she's alive and lock in the $1 million exclusion. That mom's using her $1 million exclusion to put that property in a trust, and the property tax bill will not change when she dies because it's locked in." And I said to the attorney, "I want your client to realize that the capital gain will still be sitting in that property, that if it's ever sold, it will be subject to capital gains tax based on your client's old tax basis. When your client dies, there will not be a new income tax basis. So in order to preserve the low property tax, she's going to give up stepped up basis at her death." And we went over it, and we talked about the pluses and the minuses. And that mom decided it was more important for the property tax bill to stay low than for a new basis to be assigned at death. So we went ahead with that transaction.
Yeah, another question, so about IRAs, and hopefully these are coming in sort of as we were talking about it, so this is in order. Right, who can you list as the beneficiary of an IRA? Can it be a minor? So it can, and typically when you're filling out the forms with the institution, you would have the ability to say, if it is a minor, who would you name as the custodian? So you may have a more technical way to write the minor's name in versus just putting their name down, where you would say, to my son, custodian for the benefit of grandchild. And so the grandchild's the beneficiary, but somebody has to be in charge of it until they're old enough. And that's where you would name the custodian. And every institution will have their own form that you fill out. And so you can talk to the financial advisor that's helping you, or come see us.
We have another IRA question. This is a married couple. Are you saying that the first beneficiary should be the spouse, and the second one is not the trust, but a named beneficiary? So if you want your IRA to go to your spouse, sure, you name your spouse as the first beneficiary. And now, who are the contingent beneficiaries? If you name a trust, which you may want, because you may want assets managed for the beneficiary, that trust needs to be a see-through trust or a special needs trust for a disabled beneficiary, so that the favorable IRA withdrawal rules apply, either the 10-year rule or the life expectancy rule. And just your plain vanilla trust may or may not work as that sort of a trust. So in light of the Secure Act, we're telling people, if you want to name a trust to manage your IRA assets for someone, let's take a look at that trust and see if it qualifies for the best income tax treatment.
All right, next question. Again, Prop 19, not a surprise that we're going to get lots of questions about that. So what if the parents transfer the property to multiple children before that February deadline? What are the taxes? What's the effect of that? What happens? Yeah, so you could. So a parent, let's say they have this rental property, so it's not their home, let's just say it's another investment property. They could prepare a deed to transfer it to 3 children, 1/3 equally as tenants in common, and that would be considered a gift. So on the gift tax return, you do get an appraisal of the full value of the property, and then report it that it went to the 3 children, and then it just belongs to them. And if you've done it before that, again, the deed part was done before February 16th, then you lock into the old law. And if it qualifies for the parent-child exclusion under that extra $1 million, then it qualifies and the kids keep the same property taxes. And again, what's the cost of doing that? The cost is really the fees of dealing with the attorney and maybe the accountant filing the tax return, paying for an appraisal. Those are the actual costs. And again, there's always going to be lots of trade-offs for the client. So it's something that we have to go through with them. We have this really long checklist of all these things that you have to be aware of, instead of just making an outright gift. It's there's a lot of things to think about first.
In fact, Daniel, could I just ask you, what happens to the income stream from that rental property if it's transferred to the children?
Yeah, so the income truly does have to go to the children. So that Board of Equalization, they would not look favorably if you're just trying to transfer title but retain all the other benefits of the property. They would say, that doesn't qualify. In order to get a change of ownership, which is what we're trying to accomplish by transferring it to the children, you also have to have the primary, so the beneficial interests of the property go there as well. So rental income goes to whoever actually owns it. Similarly, if the parent technically still, if it's their own home that they live in, arguably they would have to pay rent to the children to continue living there. Otherwise, again, what did they effectively do just by transferring title?
Thank you. All right, a general question about property step-up. If there's not an official appraisal done at the time of death, can the step-up still occur? Yes, so the law says, our current law says at a death, almost everything does get a stepped up basis, except retirement plans and annuities and these sorts of things. So if there was real estate and there was a death and no one got a valuation, you can always get the valuation now. They have to go back in time to figure out what was the value worth on that date of death. And the longer they have to go, it may be more difficult to kind of come up with a valuation. And that becomes the new income tax basis. And if that was a rental property, the depreciation schedule should have started again at the current value, the stepped up value, and you may be able to go and amend prior income tax returns to claim the depreciation deduction should be larger than what was taken.
Yeah. Next question, about Florida. Yeah. So there are certain states that don't have state income taxes. Florida, I believe, is one of them. A lot of people like to move to Florida for that reason. Texas, Nevada, Washington, I think Wyoming. There's a handful of states that don't have state income taxes. So again, if you're thinking of moving out of California for that reason, join the club. You can go move on with Elon Musk.
All right, let's see. This one says, I currently live with my mom and was planning on staying on after her death. We have several of these cases right now. Currently, the house is being left to me and a sibling. I think we need an appointment. And here we have the Proposition 19 areas where nobody knows. So you ever watch Saturday Night Live and they're talking about the coronavirus and there's Dr. We don't notice. So right now we are waiting for guidance from the State Board of Equalization to find out if one child remains in the property, even though it's being left to 2 siblings. Does that qualify so that there's no reassessment? And Daniel, I think we just got a memo from the State Board of Equalization.
We did, and it's something we'll talk about with each client individually because it's really their legal opinion on the law, but they say themselves this could change in the future. So it's very difficult for us to advise clients to say this, hey, we're okay in this type of situation, because even the people that would regulate that, they don't know the answer. Again, not, again, issues with California. The law was written and passed before the governing body really had any input or knew how to interpret it. So it's a tough, and the fact that the deadline is coming up so quickly, it's hard to do it, consistently for everybody. So it is something that.
Although if I may put in my 2 cents,
Yes.
I don't know that this is subject to the February 16th deadline. So in other words, if mom could still revise her estate plan even after February 16th, and we're going to be doing a lot of this, to say what does happen to that primary residence. Does it stay in trust for my daughter who has the right to live there for the rest of her life? And for that reason, it does qualify. But you're right to say we don't know all the answers yet, and this will become more clear as the weeks and months go on.
And naturally, just kind of the next question that most people ask is, what if, let's say, I do live in the house after my parents pass away, keep the same property tax bill. What if I move out, after a year or 2 years, I just don't want to live there anymore and I decide to rent it out? What's going to happen then? Are property taxes going to go up? Or because I qualified at the time of transfer, does it stay low? We don't know. Again, the Board of Equalization has given their opinion on what that means, but that is always subject to change. So it's not a great time to be an estate planner when you have all these issues.
Should I take that?
Sure.
It's like a bar question. Here we go. Dad dies, mom transfers property, for example, her house, from herself to an LLC or S corporation that has both her and her adult child on it. Is it done with the step-up basis from the dad's death? And here I'm going to talk about buckets. So we keep trying to separate. There are income tax buckets, there are property tax buckets, all kinds of buckets. So this question is a 2-bucket question. When dad dies, there will be a stepped up basis on the entire property if dad owned it, or it's dad and mom as community property. There would be a new stepped up basis. So that's the income tax bucket. Now we're going to look at the other bucket, the property tax bucket. And here we're going to see that transferring property to an entity may be a desirable thing to do after the parent-child exclusion has been shrunk down to very little. And I'm going to tell you it takes a lot of planning, and I'm going to give you just ideas. Should the property be transferred directly into the LLC, or should the property first be transferred to the children, who then contribute their share and mom contributes her share to the LLC? It's going to make a difference, because then we're in the world of the entity property tax rules. We're not going to cover them today. So before you transfer real estate into an entity, you definitely need some guidance.
Okay. Next question, and again, we'll keep going. As long as you have questions, feel free to log off though if you feel like you're done. So what about property held in Trust B? So again, mom and dad had an AB trust. Dad died, the trust divided into A and B, and there's property in that B trust. What happens when mom dies? Will it be reassessed under the new Prop 19 law, or will it stay the same? Again, it's a bit unclear. Attorneys have come down on both sides, but again, for a client, we would kind of go over it on an individual case-by-case basis and give you our opinion on that. So it's something that we would have to look at in each situation.
I'll even tell you that Daniel and I have been arguing about that issue in our office, and we're waiting for the Board of Equalization to tell us the answer. Okay. Will my husband's inherited IRA automatically transfer to me if he dies? He is currently the only designated person. Thank you for doing this. Thank you very much. So the question is, who has your husband named as beneficiary of his inherited IRA? You think, oh my God, now you have to have a beneficiary on an inherited IRA account. Yes. So if I inherit an IRA and I go and set up an inherited IRA account, which I can do, so I don't have to pull it out right away, I need to name a beneficiary on that account. And if he hasn't done so already, he needs to do it with the institution where it's located, name a first beneficiary and a second beneficiary.
Okay. Next, right, so a question about back to Proposition 19. What if the parents sell the property to the child and take back a note? If there's no gain to the parents because they're able to use their 121 capital gain exclusion on the first $500,000 of gain, would that work? And again, if the transaction, the transfer occurs before February 16th, it would qualify under the old law. So that would be something to look at for a client. So I agree, we could talk about that.
Well, here's a long one. There are two houses. One is being lived in by parents and they own a house that is being rented. What is the best decision now? If someone wants to move into the parents' house after death, what should you do to benefit property taxes versus capital gains? If both houses have greatly appreciated, what is the $1 million you were mentioning? Is there a benefit to changing ownership for the rental? So you see what we get involved with? We're going on vacation on February 16th. This has been going on now for months.
February
Okay.
17th.
I respect your question. Okay, so one house is being lived in by the parents, so that's their primary residence. If a child wants to move into the house after their death, that child can retain their Prop 13 property tax base. They get their parents' property tax bill if they're willing to move into that house. So that will work. Is it fair to the other children? That's a question. The house will get a new basis, income tax basis. That's the income tax bucket. They'll get a new basis. And for the property tax bucket, it will also preserve the property tax bill. So that's a good thought. And what is the $1 million you were mentioning? What about changing ownership of the rental? So the $1 million exemption, poof, it's going to expire on February 16th. It won't exist anymore. So if parents want to transfer a rental property to their children, they have to do it by February 16th. So the clock is ticking. When they die, they will not get a new income tax basis on the property. The children are going to carry over their parents' basis. If they ever sell the property, they will be responsible for the capital gain. They could do a 1031 exchange. That's an option later so that they can get out of the property and not pay the capital gain unless they repeal that law. So you're thinking along the right line. That $1 million, that's the exemption that's disappearing.
Yeah, next question talks about charitable giving and leaving an IRA to a donor advised fund. And yeah, that's a great idea. So if you have an IRA or just generally in your estate plan, you would like money to go to charity, tax-wise, it makes the most sense that it comes from an IRA, because then you're minimizing the tax liability on the other assets that you own. Because when an IRA is payable to charity, then they do not have to pay the income taxes on it, whereas it would be if they pays to an individual. And some people create these donor advised funds, so it's like a mini private foundation that you've created. And if you have your IRA payable into that, then it continues to be managed by the donor advised fund. And as long as you name a successor, I believe, owner to the donor advised fund, they would be the one to decide how much goes out every year and can also pick the charities. And so that is a great idea, that if you work with your financial advisor and your estate planning attorney and the institution that would hold the donor advised fund, that you could have it payable in there. And then it does add much more flexibility on which charities get the money in the future.
Okay. It says, so I need to change my second beneficiaries on my IRAs and 401ks from the trust to my individual children. You were listening. So if you make the second beneficiaries the children by name, clearly they are eligible for the 10-year withdrawal period. If you make the second beneficiary your trust, it will be eligible for the 10-year withdrawal if it is a see-through trust, where clearly the children are the designated beneficiaries. There's no other beneficiary like a charity, even though we're not saying, don't include charities in your trust. It's just that that trust must be written in a certain way. So if you have responsible children, that's fine. They can decide how long do they want to take it out. They can name whatever beneficiaries they want at their death. Sure, name the children as beneficiaries. But if you want it managed for them, or protected from their creditors, or protected from a divorcing spouse, or you want to say where it goes when they die, if there's anything left, then you do want it payable to a trust, and the trust must be written in a certain way. Lots of times we call those IRA trusts, where we know they qualify for the 10-year withdrawal period.
Yeah, so I think that's all the time that we have. Thanks again, everyone, for showing up and spending all this time with us. And so again, there's our contact information on the screen. So if you have any questions, you can call or email. And we hope you're all doing well and being safe out there. And hopefully we get to do this in person sometime soon. Thank you, everyone.
Thank you. Bye-bye now.